ZanuPF versus citizen chaos erupt after Ziyambi and Mabiza Reject Referendum. Kusangana kwatinoita pana pa YouTube channel yenyu Magaba News patinobata nhau dzinenge dzichiitika munyika yedu yeZimbabwe tichingokurudzirana kana uri mutsva, kindly support us by hitting the subscribe button. So today we are at the center of its Attorney General Virginia Mabiza and Justice Minister Ziyambi alongside the ruling party ZanuPF. Their opposition of constitutional amendment bill, especially ruling out a referendum, has triggered frustration among many citizens and civil society group who feels left out of the decision that affect the future of the country. So today we are looking at this issue from the perspective of ordinary Zimbabweans. So today takabata nawo iyi tichitaura munyika yedu yeZimbabwe sezvo Ziyambi na Attorney General Mabiza vouya vachitaura vachiti ivo paurongwa hwereferendum hakuna referendum, ari kuti pazvinhu zvese zvatiri kuita izvi hazvina basa nereferendum, vachi director vanhu kusection 328.6 iyo yavazivisa Attorney General Mabiza vachiti section 328.6 is a deliberate and perceive that it receive the ultimate democratic veto and the national referendum for only three narrowly defined category of amendment: any bill that attaches Chapter 4 and the Declaration of Rights, Chapter 16, Agriculture, Land, or Section 328 itself. Roma Shoko, Attorney General Mabiza vachiti, I should emphasize that the constitutional base for process without a referendum is neither an option or none a loophole. 328.6 is very clear on its aspect. Any insistence on a referendum given the current scenario is devoid of any meaningful legal basis and logic. It is an unconstitutional demand, as said Mabiza. So ndo mashoko ari kutaurwa na Attorney General Mabiza vachiti tikaenda kusection 328.6 hakuna zvinomotaurwa zvekunzi zvereferendum, and the position iyi haitomode members of parliament, haitomode kana citizen munyika yeZimbabwe kuti pachinjwe bumbiro remutemo iri, kuratidza kuti havachatotrust members of parliament ari muparliament, vari kuda kungochinja zvinhu izvi according nepati yavo, according nehurumende yavo, kuti vanototi takusvika 2030 vari kuona kuti members of parliament havari kutemba kuti inongovotwa nemamembers of parliament, vari kuona kuti ivo varimo vacho veZanuPF havachatotende nehurumende yava Mnangagwa, vanogona kutovhotera kuti havasi kubvuma chiitiko che2030. So according to communication across communities, churches and civil society platform and common messages emerging, people want to be heard. Many citizens are not necessarily arguing legal technicality, including they are raising a deeper concern that decision with a long-term national impact should reflect the willing of the people, not just the strength of numbers in parliament. When Attorney General Mabiza and Minister Ziyambi emphasized that a referendum is not legal, require citizens hear something different. They hear that their direct voice may not be considered necessary, and that is where the discomfort begins. For many Zimbabweans, the constitution is not just a legal document, it's a social contract. It represents the collective agreement of the people about how they should be governed. So when changes are possible, especially those that could influence leadership or governance structures, citizens expect to be actively involved, not just represented. There is also a growing perception among critics that the current approach appears to be to benefit those already in position of power. Whether that perception is accurate or not, it is shaping public opinion in a powerful way. And in politics, perception can be just important as reality. From the citizen point of view, the issue is simple. If leaders are confident that changes are in the national interest, why not allowing the people to directly endorse them? Why not open a process where they invite more dialogue and build a strong consensus? These questions are not necessary act of the defiant. They are cause for inclusion. At the same time, it is important to acknowledge that Zimbabwean constitution abandoned during the 2013 Zimbabwean's constitution referendum does not provide a framework for how amendment should be handled. Government officials add that they are following that frameworks, but citizens are now challenging whether that frameworks as applied today is enough to meet current expectation for transparency and participation. This is where the real issue lies, not just what is legal, but what feels legitimate to the people. Because when citizens begin to feel disconnected from national decision making, trust begin to erode. And without trust, even lawful processes can face resistance. As Zimbabweans navigate this important moment, one thing stands out clear. Citizens are not just asking for answer, they are asking for a seat at the table. The position taken by Virginia Mabiza and Ziyambi may be grounded in law, but the response from the public shows that legality alone is not enough. In a democracy, listening matters, engagement matters, and above all, the people must feel that their voice counts. What's your view on this issue? Should citizens have a direct say through a referendum, or should Parliament decide? Let's discuss in the comment section. Don't forget to like, subscribe, and share. I will see you in the next video. Dokutenda nekutsigira kwamaita channel yedu Magaba News.